Our next questions on Mohammedan law is question number 28, which asks who are the sharers under Hanafi law of inheritance, and question number 29, write explanatory notes on right of representation and doctrine of all and rot. So, regarding the sharers under Hanafi law, we found the following classes: the sharers, the residuaries, the distant kindred, and finally the state. So, all those relations by affinity of marriage or relations by blood are falling under the sharers, while the residuaries or the descendants, ascendants, and the collaterals. So also regarding the distant kinder, we found the female agnates, cognates, both males and females, and the best classification of distant kinder would be descendants, ascendants, and collaterals. So, as per the very traditional and classical Mohammedan law regarding the very provisions relating to succession or on law of inheritance, as we found there are 9 groups of persons who fall under succession to the property of a deceased Muslim, and they are the agnates, those relations through males, and cognates, relations through females, and those collaterals like the descendants in the parallel lines from a common ancestor or ancestress, which includes both agnates and cognates. So also the number 4 group of persons falling under the law of inheritance or succession regarding the property of a deceased Muslim or the true grandfather, the false grandfather, the true grandmother, the false grandmother, the sons, how low soever. So all lineal male descendants, and lastly, sons, daughter, how low soever, the female children of lineal male descendants. So all these categories of persons are all those persons in these 9 groups are falling under the line of succession as per law of inheritance under Mohammedan law regarding inheriting or succeeding the properties of a deceased Muslim, and regarding that certain rules or principles are itself provided under the classical Islamic law, and out of that one very important one is right of representation, and that is otherwise called, in case of succession or partition of ancestral property, it is used for determining the heirs and for determining the very quantum of share of an heir or a group of heirs. So also another very doctrine that is applied is the doctrine for stripes, and that doctrine is all about where there are branches. The division of property takes place according to the stock. For example, at the places where branches bifurcate under the Hanafi law, no aspect of the doctrine of representation is recognized, but for calculating the shares of certain heirs, the Shias apply both doctrine of representation and doctrine of stripes. So, this is the very difference we found among the Sunnis and Shias regarding application of the doctrine of representation and doctrine of stripes. And besides that, there are two other important doctrines relating to law of inheritance or succession under Islam. One is doctrine of all, and the second one, doctrine of Rad. So, while doctrine of all is all about increasing while distributing the very quantum of share, and under doctrine of Rod, the very returning of those quantum of shares of a legal heir. So when the shares given to the sharers are equal to the unity, no problem arises. But when the sum total of shares is either less than the unity or more than the unity, the problem of reduction of shares or the distribution of balance arises. So when it is reduction of shares or distribution of balance, then the very doctrine of all and doctrine of Rod is applied. While the Sunnis recognize both the doctrines, the Shias only recognize the doctrine of Rad, the second one. So, another aspect regarding law of succession or law of inheritance under Islamic law, we found that the Shia law, legal heirs of a deceased Muslim fall under the following categories, such as nasab or blood relationship, and the second categories are sabab or special relations like the status of spouse or special legal relationship. But in India, we found something different, as it is found under the classical and traditional Islamic law relating to succession and inheritance of the property of a deceased Muslim. So, as per India, the very legal heirs are out of marriage, and that is only the husband and wife, and those heirs by consanguinity, and which includes parents, children, and other descendants, even the grandparents, brothers, sisters, and their descendants. So also the paternal uncles, aunts of the deceased Muslim. So this line of succession or inherited legal heirs, as we found in India, the heirs in an earlier group exclude the heirs in the latter group, and the heirs in both the categories of a group inherit simultaneously. And lastly, that one thing we have to touch, that is to state and how it becomes the part of public treasury, as there was no legal heir, or there is no legal heir to claim the properties of a deceased Muslim, then naturally those properties of that deceased Muslim will go to the state and it becomes a part of public treasury. So, this is all about law of inheritance or succession, as under the very question number 28, who are the sharers under Hanafi law of inheritance, and under question number 29 regarding right of representation, right of stripes and doctrines of all and rod, and so also all that we have discussed regarding those certain notes relating to bequeathable thought, apostasy, mutawali, marjul mat, doctrine of stripes, gita musa, all these already we have discussed in detail in our previous videos. We have already uploaded under Muslim law in India. So one can refer to our previous videos uploaded in this channel to find out the correct and the exact appropriate answer to all these questions.